Oh, that's new.
Court calls the matter of Duncan versus Brookens, case number 2014-5744-DS. All parties and attorneys could please state their name and appearance for the record, starting with the plaintiff's attorney, Ms. Coffrin.
Good morning, Your Honor. Serafina Coffrin appearing on behalf of the plaintiff, Amber Duncan.
Good morning, Your Honor. Attorney Crystal Grantham, appearing on behalf of defendant John Brookens II.
Good afternoon, Maggie Gleason, guardian ad litem.
Good morning, everyone. I see both Mr. Brookens and Ms. Duncan. Today's date and time set for hearing due to the decisions of the Supreme Court and Chief Judge. This matter is being held by remote technology. Contents of this video may be the official record of the proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, alteration of said content is strictly prohibited. Today's date and time, we have for a motion to enforce judgment and an order and request to suspend reunification efforts. And Ms. Grantham has entered her appearance on this matter. I know there's some other matters in front of the referee with regards to child support, but counselors, where are we at with this matter at this time?
Your Honor, we were before this court on April 5th. There was a ruling that he was to immediately sign a Skywood Recovery Authorization Disclosure form. We sent it to him on April 7th via mail and email. The postal version included a self-addressed stamped return envelope. There were communications between his office him and I. We resent it again on April 12th, again via mail, postal mail, in addition to email, trying to make it as easy as possible, but he didn't sign it. I think that it's kind of undisputed that it's a really, as far as enforcement goes, there's an order that he's to immediately sign it. He didn't sign it. We filed this motion to enforce it for him to sign it. He was clearly present at the hearing. There's really no reason for him not to have done it before we filed the motion. And then we filed this motion, we signed it and submitted it April 21st. And here we are a full month later, and still, while this is pending, knowing that there is contempt/enforcement proceedings pending, he still hasn't signed it or returned it to our office. Now, at the last hearing, I know we keep having these review hearings, he submitted, information from his therapist, essentially saying that he was okay, but he's not denying that he was in Skywood recovery. I think it's reasonable for this court to have a presumption that since he was at an addiction center due to addiction, and that because his therapist report didn't say anything about addiction or inpatient treatment or anything like that, that it's a reasonable conclusion that he didn't tell his therapist about it. And that there's no reason for this court to think it's safe for him to participate in reunification efforts at this time. Further, since the last hearing and since we have filed our motion to enforce, Ms. Alexander, the reunification counselor, Ms. Alexander, has issued at least an email opinion or notice, and she had requested a hearing as to terminating the reunification efforts. So we are asking not just for some sort of sanction or something to compel him to actually get those records if reunification efforts are going forward, or to just put an end to the reunification efforts because he's clearly not complying.
Okay. Ms. Grantham, any position first on the Skyward release to be signed?
Yes, Your Honor. So, and back in 2019, he was also ordered to provide his mental health therapist information, the medicines he's on, and all of this was complied with. And the last thing he wants to happen this time, like what happened last time, is that it would be reviewed by his children. He at this point, he has been defeated. He has realized the idea of sending over this type of report he finds to be very invasive. He was not there because of drugs. He was there because of the stress of this case after finding out that the reunification counselor as well as the guardian ad litem had shared with him that the children, it wasn't something that they wanted to go forward with, and that at that point, he loves his children very much, and he's not willing to continue to put this through them. So all of these efforts have been successful in alienating him from his children. He hasn't seen his children since they were 12, 11, and 4, and now they're 15, 14, and 7. And this has been going on since 18. And at this point, you know, he doesn't want to send in his Skyward recovery authorization form. It's too invasive. If it was another way to provide the information the court needs to see that he would in fact be fine to see his children, that would be something we would consider. But at this point, this was enough for him to say, okay, they went. In regards to him ever being able to see his children again.
Okay, he understands though it's not his decision, it's a court order. Is he saying he's not going to abide by the court order and sign the release?
I guess where he is at in this is that he doesn't want it to go to the plaintiff so that the children can see this and this can be used and aired out. He felt overwhelmed by this court case and missing his children, and he went in on it to make sure he was okay because he felt overwhelmed. So if there's another way to provide the same information to make sure that in fact he is okay, and what the therapist did state in the April hearing, he's willing to do that. But at this point, if in order to see the children and have a relationship with his children would be that he now has to release and his medical records, which are very invasive, he's at this point willing to concede and unfortunately, but we're going to have to structure some sort of agreement with notice, because I know there's another issue with an orthodontist bill. And I think he has a right to know when they're going and at least be sent a bill so he knows about it and can plan to make payments or a payment. So she doesn't communicate. And so that's going to be something we're going to have to deal with next, because she's been successful in parent alienating him, and he's not willing to go any further because he doesn't want his medical record to be aired to the community.
Right. Ms. Grantham, that's combining two issues that are completely separate. The orthodontist issue will be handled by the referee. Okay. And number two, this long history of this case, could there be some alienation? Sure. But your client has done plenty of his own to destroy that relationship with the children. So I'm not going to relitigate the years of testimony I've had to listen to. It's a two-way street. There's faults on both parents' side, but to say it's only alienation, your client isn't being honest with you. I encourage you to watch all of the tapes and the evidence if that's what he's feeding you. Could there be alienation? Sure. I'm not ignorant. I know how this works, but to say it now twice, this is not mom's grand scheme. It's faults on both sides, but your client has a lot to deal with on that. Ms. Gleason, I mean, I got to ask Ms. Gleason's opinion on this. I guess I could do an in-camera review of the medical records. But if it's drugs or alcohol, Ms. Coffrin has a right to know if that's going to go forward on you know, I could always redact if there was something said that has nothing to do with parenting, but you know, that's something that can be argued. But Ms. Gleason, what is your opinion with regards to the Skyward release?
I spoke to Mr. Brookens last Thursday in preparation for all the hearings that have been scheduled. When I spoke to him because he didn't have an attorney. I now know he has an attorney, and I specifically asked him about the Skywood release. He said he'd signed it. So I don't know all the details of whether he's signed a blank release or whether any release was signed. In regards to medical history, of course, that's highly confidential, and release of that could impact, if the children got a hold of that or were aware of it, that could damage and alienate affections. I don't have any suggestion or evidence that the mother would release an actual report to the father. I believe she understands that would be really damaging. Children they internalize information like that, and I don't think that should be released in that sense. I do think that this has been dragging on far too long. The court ordered the information to be released. If an in-camera review of the medical records occurred, that's something that would be much less open to the public, of course, or to anyone involved. And it would narrow the scope of the review. I don't, to this date, know why the father went to Skyward. I don't know if it was for a specific drug or alcohol issues or just for therapy and counseling. I don't know the answer. I haven't been able to determine that. But I think this has dragged on long enough, and the court needs to know if the reason that the father was in therapy or in treatment could pose any further damage to the children. That's what I think.
Okay. Well, Ms. Graham, your client's been ordered to sign it. As of today, it still hasn't been signed. There's also a request to suspend the reunification efforts, correct, Ms. Coffran?
Correct, Your Honor. So part of our motion and part of the enforcement was to suspend it pending the release of this information. And quite frankly, I can understand and appreciate as far as brainstorming to have an in-camera review. However, whether or not he is capable or has the capacity to safely engage in reunification efforts is a key issue in this matter. It's the children with their mental health issue, father with his mental health issue. And so to cut us out of that so that we have no ability to respond or review, especially considering that he consented to the release of this information to me many times. And this court's order, if we go back or review the hearing tape, I remember this court pulling up the old consent order and saying, you consented to the release of information. This court's order for the Skywood Recovery Center release form was just kind of like an enforcement of a prior agreement. It wasn't some brand new revelation that suddenly he has to start disclosing information. This is what he agreed to. And he agreed to it generally. And Your Honor, you just made it specific that to comply with the prior agreement as a part of the prior, that was going to continue, especially because he can't come to court and present his therapist's opinion saying that he's fine and then withhold any ability for me to cross-examine or double check or compare those records if I'm cut out of it, quite frankly. Further, what is very, very interesting about their argument is that they're saying he just went there because he was stressed about the reunification therapist and he was stressed about the guardian ad litem's report because but he went there, I believe, in January or February. The therapist's opinion that we've submitted a request for a hearing about, that was just like a week or two ago. That wasn't very much. So, I mean, they're convoluting or trying to, mix up the timeline here. If you went there in January or February, before the decision hearing, before anything, And now they're saying that the reunification therapist's opinion is why he went there in the first place. That doesn't make any sense, especially because, I mean, I don't even know where to go from this other than the fact that this is some clear information. And if what he's saying now is true, that he just went there because of the stress of the action, that he didn't go there because he was required by his job, or he didn't go there because of methamphetamines or whatever it is that, that an addiction center. If that's true, that he was just there because he was stressed out, well, why not show that? Wouldn't that actually support their position that he's not unstable? So their argument does not make sense. It does not make sense from a timeline perspective. It doesn't make sense from a, what are they even arguing perspective. If their main position is that he is sane and he is capable of participating in reunification and he's all good, and he just went there because he was a little stressed out, well, show it. So don't cut us out of the process, and then don't use this as a kind of a strange late motion for reconsideration to undo this court's prior order. There was a time and there was a place for that. And that time period has passed. With regards to their, they're saying they're concerned about the children getting a hold of it. There's been no evidence at any point, or no, this is a brand new allegation that somehow the children are getting a hold of his records. I don't know where that's coming from. Granted, it's a creative argument, we can appreciate it, but I echo the guardian ad litem in that she says that she doesn't have anything to suggest that Ms. Duncan would release it to the children. And we ask that the court disregard that concern and just maintain its prior orders. Notably, they didn't file a motion to undo the order. He's clearly in contempt.
Ms. Grantham, anything else before I mean, he's not signing my order. That's contempt. I've ordered him to sign, I'm sorry, he's not signing the release. I've ordered him to do so. I can set it for a hearing, but I will guarantee you this. If he did go there for some drug and alcohol things, that wouldn't concern me so much. But if I eventually do get the medical or the Skyward information, and it's presented that he was there for drug and alcohol, I say good for him because he's dealing with his problem. But bad for him because he's been lying to everybody. That's my biggest problem. And I will look at the costs. I mean, I don't want to put him in jail, but I can't see any path to reunification without all the information on the table. I just can't. So he can blame the mother for alienating, but if he doesn't sign the release, how could I possibly go forward with reunification? So I'll set this matter for the show cause and the offer or motion to suspend reunification efforts. And it probably won't be until August. And if he signs the release, great. I don't understand the gamesmanship of it all, but okay. But if he doesn't, I don't see a path to reunification, and that is not my choice. That's not, maybe the mom's choice, but Ms. Coffin and Ms. Gleason and yourself, Ms. Grantham, have a job to do, present the evidence. I need the evidence, but I will consider attorney fees for going through all these hoops. We're gonna have to see if Miss Duncan should not be paying to make Mr. Brookens follow court orders. So I'll set it for a hearing. And most of it all, and I know I have a notice from the therapist about reunification efforts. I'll ask the guardian ad litem until we can get this matter in August, should the children continue with the reunification therapist at this time or suspended?
May I respond, Your Honor?
Yes, go ahead. Hold on, Ms. Gleason. Go ahead, Ms. Grantham.
So in regards to the motion to suspend or reunification, where my client stands right now is he's given up on being able to see his children or custody. It was very clear to me this morning, and it is true, I just came on board. And this has been extremely difficult on him. And when he did hear recently from the reunification counselor as well as the guardian ad litem to hear that the children were not ready to see him. They didn't think it was a good time for the children. That was enough for him because he doesn't want any harm to his children. He doesn't want them to continue to go through any of this. It's been going on since 18. So at this point, I know I'm coming in kind of late to the game and, or excuse me, not game, pardon me, late to the proceedings. I believe that Attorney Ward was his attorney and then got a different job. And he did come to court the last few times without an attorney. And at this point where he stands is he doesn't want to continue to push for custody. As far as he's concerned, he feels defeated in there. And he did go to the mental health facility because he was overwhelmed because of continuing.
I'm going to stop you there, Ms. Grantham. I cannot have you repeat again.
Okay.
You want your client placed under oath? If he wants to say he's done for his reasons, he can do that. By law, I have to have reunification, not efforts, but I have to do checks.
Okay.
We can't just say you're done, see the kids when they're 18. We have to set it for a review hearing every year just to see if anything's changed on either end. If your client wants to do that, I can do that today, but it's his choice. It's nobody forcing him. It's his choice. And if he's going to go on and on about how mom did wronged him, I'm not going to relitigate the trial. Does your client want to be placed under oath and say, I quit, I've given up? That's his prerogative. But I can't just accept it's all mom's fault. He has to say the words of what he wants to do from this day forward. Does your client want to do that?
My client can't afford to continue. So he wants to say those words.
Okay, then we'll ask Mr. Brookens to unmute himself. And I'll place him under oath and he can tell me what he wants to do with this case. Mr. Brookens, if you'll raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your full name, spelling your first and last name for the record.
John, G-L-H-N, S. Brookens, B-R-O-O-K-E-N-S, the second.
Okay, Ms. Grantham, you're okay with your client speaking freely at any time? If you want to jump in and tell him not to, you can as his attorney, okay?
Thank you, Your Honor.
Mr. Brookens, I need to know what you want to do and what is your choice to do today?
I am okay with stopping the reunification process. Talking to Ms. Gleason, dealing with Cricket. We're good. I am ready to be done with it.
Okay.
And not just for me, just for them too.
You understand that if we stop reunification efforts with no parenting time, there's no plan going forward. We will check in on a yearly basis, which means you can change your mind, but then we'll have to go through best interest again at that time. You understand that?
Yes, I believe everything that went down in the court and the way you handled this is perfect. I mean, you did your job, and I think I'm good.
I know it's not what you want, but rather than keep going through litigation and open up those Skyward records, are you saying at this time you think this is not only best for you, but in the best interest of the children, not to put them through this?
Yes, it's good for us. I mean, it's with my counselor, and it's just good to be done.
Ms. Gleason, any position as the children's attorney?
Well, Your Honor, what the father just stated under oath is consistent with a conversation I had with him on 5/20/21. I do need to state that I don't talk to people who have an attorney. And at that time, when I spoke to him by phone, he didn't have an attorney that I was aware of. And so I apologize to Miss Grantham if he hired her right before that or after. In any event, he stated to me during the conversation, we talked about the Skyward release. We talked about paying child support. We talked about his desire to have contact with his children. He stated to me that he loves them, But if they don't want to see him, he understands that for now. And basically he said, I'm okay. But he wants to, quote, let it go. That's consistent what he has stated today. And I had been under the impression that he had signed a release. Maybe it was a limited release. I don't know. But this has dragged on for a long time. I do believe he is looking at what is best for his children now. I am aware of the reunification therapist position. And at some point, you have to stop fighting tooth and nail in court. You have to start thinking about, how do these children calm down? How do they move on and have a stable life? How do they stop having to go to counseling forever and ever and relive things? And I think that, as odd as this may sound, I think Mr. Brookens is doing what he thinks is right for his children. So his statement today and what his attorney has stated is consistent with what he said to me last week.
Anything, Ms. Grantham?
No, Your Honor.
Ms. Coffin, anything?
Yes, so I guess I would ask Mr. Brookens if he agrees that continuing the reunification efforts is mentally harmful to the children.
I would have to object to that question because he's not going to know what's mentally harmful to the children.
Ms. Coffin, he has decided not to continue with the reunification efforts. He says I believe him. And I'll be honest, Mr. Brookens, I've had you testify a lot. There's sometimes I believe you, sometimes I don't. This one, I believe him. He's doing it for him and his children.
Okay.
Okay.
So the court order, if a court order is coming from this, it would simply say
It will.
All reunification efforts as previously ordered are terminated.
Yes.
Okay. My concern is that if he, for instance, next month files another motion for reunification, then is future reunification, hopefully we don't have to start from the very beginning again. So that's kind of my question. Like, where do we go from here? Yes, annual review hearings, and that would be fine, but what happens if he files a motion? Do we pick up where we left off?
Okay. I will, and I apologize. I have other matters today, but this is probably the most important matter I'm dealing with today. So we're gonna let the 11:30 know that it'll take some time. Mr. Brookens, I'll ask you the question. I can't prevent anyone from filing a motion, but you could file a motion to reunify tomorrow. You understand that, correct?
Correct.
You understand that the odds of that happening is pretty much nil. It's not going to happen. You understand that, correct?
Yes.
Okay. What I'm talking about is if in probably a year or 2 or 3, and I think one of the children will be 18 by then, you have evidence that you've turned your life around. And I don't think you're living a horrible life. I'm not judging you on that, but there could be a motion. That's what Ms. Coffin wants to make sure is you're not just going to wait 6 months, everything cools down and come back in. You understand, for me to even consider reunification, it's going to be a long shot. You understand that?
Yes.
Okay. Because even though I think you're doing this for the right reasons, yourself and your children, the kids may think you're quitting on them. But I look at it as you're putting the kids' interest above your own. So I can't really reopen the kids to the pain and suffering. Every year we have to do a review, and the kids really don't need to know about it. The parents will be here, the attorneys will be here briefly, and if Mr. Duncan says, no, I hear through the grapevine kids are doing well, I'm happy, I'm doing better, but I'm not interested in reunifying, then that's fine, okay?
Mm-hmm.
So I can't prevent anyone from filing anything, but Ms. Coffin, I think you know me well enough, but I want Mr. Brookens to know it's a long shot, especially in the first couple of years. So it's going to take time for you taking care of yourself and the kids healing. And a lot of times it doesn't happen until they're adults, and then they'll make a decision as an adult. So Ms. Coffin, does that answer your question?
Yes, yeah. If a motion is filed in the future to reinstate parenting time, then would all of the therapy, disclosure, and other obligations and various reunification orders, are they in effect once again?
Yes.
Okay.
I am not going to start from scratch. It would be, I want a release on everything. Don't waste everyone's time until those are all signed.
Okay, and then until, because there was ample testimony and also there was a lot of discussion about contact between Mr. Brookens and the children. So until such time as there is a parenting time order in the future, then are we continuing that his only contacts or communications to the children would be if mother agrees or if their therapist says it's okay? Because there was
I would
the
say if it-
discussion testimony as far as the trigger. I don't want this to suddenly we're out of court, so then now there's a whole bunch of these triggering
Nope.
events or contacts.
Whatever the contact provision that was in the past order will continue. I'll be honest, I don't recall exactly what that was.
I don't-
He was
No,
allowed to
Mr.
give letters. He was
Right.
allowed to send letters to the children. That's
No,
correct.
It was a weird situation where he had never been specifically prohibited from contacting the children, but he never did contact the children, or rarely. And then there had been testimony about when he had contacts about the effect on the children of that. And then there was discussion when Miss Alexander was testifying at the last hearing, where the court said, well,
Okay,
maybe.
this is what I'm gonna do.
Yeah.
There will be no contact between Mr. Brookens and the children without the mother's consent in writing.
Okay, thank you.
You know, and I don't know, maybe mom saying and, send a birthday card may be good for the kids or it may be damaging. I'll let mom decide that.
So the order with regards to, since there's no more reunification efforts, then is Ms. Liebert still, like, is the guardian ad litem order? I've just never had this situation. Does the guardian ad litem order stay in effect or is she released or?
Ms. Gleason will be asked to appear at the review hearing, which, like I said, by law, we have to have. So in 1 year, I'll authorize funds for Ms. Gleason to chat with the children a few weeks or whenever she feels appropriate before the next hearing.
Okay, and then with regards to the reunification therapist, we can provide her notice that she's done as well? And that there's not
Yes,
gonna be another
Mr.
hearing?
Brookens
or-
has determined not to go forward with reunification.
Okay. And the court's prior order with regards to the sharing of the reunification therapy expenses, those that still continue?
If there are any outstanding bills, those orders remain in effect, but that'll
Okay.
stop today. So if mom decides, I still like this therapist, I want to have the kids with her, that's not for reunification purposes.
Right, understood. Okay, well, I have no further questions.
Any questions by anybody?
No, thank you.
Oh, I have no doubt this is a difficult decision on Mr. Brookens' part, but I will respect his decision. I do not think it's selfish. I think it's a combination of looking out for the children and his mental health. So I will accept it. Ms. Cochran, if you could prepare the order. Hold on, I have my staff saying something.
So we technically had a GAL report.
I will cancel the GAL report that's due in October, and I will set it to be due May 1st, 2022.
Oh, that's right. So we had a hearing. So that one's going to be canceled and we'll have a review hearing in May 2022. Okay.
I'm sorry, the time, May 1st, 2022, at what time?
Well, no, that's not the hearing
Just a
date. That's
report?
when your GAL report is
Okay.
due.
May
So we'll
21st,
look
all
for
right.
a hearing date not long after that.
All right. Just wanted to confirm.
We'll cancel the June 8th hearing that was sent out with regards to the notice filed by the therapist. There may be some child support issues with regards to a referee, but that's not before me today. Okay,
Okay. Thank you.
All prior orders not affected by today remain in effect. And we will be adjourned. Good luck, everybody. And I don't know. I've done releases where parents release their rights, and I always tell them that is probably the most parental thing a parent can do, is put their children's needs above their own. But no matter what is said about you, sir, what you may or may not have done in the past, you will always be their father. And we find through studies and trainings, most kids, once they reach their 20s, are interested in reconnecting. So whatever you're going through in life, Mr. Brookens, I hope they find someone that's doing very well, not financially. Kids don't care about that. Someone who's stable and has an open heart if they seek you out. Okay?
Thank you very much.
Good luck, everyone. We'll be adjourned.